William Shakespeare taught us in The Tempest, what's past is prologue. That time-tested axiom applies to today's Commission action. In 2008, the FCC tried to reach beyond its legal authority to regulate, and it was slapped back by an appellate court only 8 short months ago. Today, the Commission is choosing to ignore the recent past as it attempts the same act. In so doing, the FCC is not only defying a court, but it is circumventing the will of a large bipartisan majority of Congress as well. More than 300 members have warned the agency against exceeding its legal authority. The FCC is not Congress. We cannot make laws. Legislating is the sole domain of the directly elected representatives of the American people. If the majority is determined to ignore the growing chorus of voices emanating from Capitol Hill in what appears to some as an obsessive quest to regulate at all costs. Some are saying that instead of acting as a cop on the beat, the FCC looks more like a regulatory vigilante. Moreover, the agency is further angering Congress by ignoring increasing calls for a cessation of its actions and choosing instead to move ahead just as members leave town. As a result, the FCC has provocatively charted a collision course with the legislative branch. Furthermore, on the night of Friday, December 10th, just 2 business days before the public would be prohibited by law from communicating further with us about this proceeding, the Commission dumped nearly 2,000 pages of documents into the record. As if that weren't enough, the FCC unloaded an additional 1,000 pages into the record less than 24 hours before the end of the public comment period. All of these extreme measures, defying the D.C. Circuit, Congress, undermining the public comment process, have been deployed to deliver on a misguided campaign promise. Not only is today the winter solstice, the darkest of the year, but it marks one of the darkest days in recent FCC history. I am disappointed in these ends justify the means tactics and the doubts they have created about this agency. The FCC is capable of better. Today is not its finest hour. Using these new rules as a weapon, politically favored companies will be able to pressure 3 political appointees to regulate their rivals to gain competitive advantages. Litigation will supplant innovation. Instead of investing in tomorrow's technologies, precious capital will be diverted to pay lawyers' fees. The era of internet regulatory arbitrage has dawned. And to say that today's rules don't regulate the internet is like saying that regulating highway on-ramps, off-ramps, and its pavement doesn't equate to regulating the highway themselves. What had been bottom-up, non-governmental, and grassroots-based internet governance will become politicized. Today, the United States is abandoning the long-standing bipartisan and international consensus to insulate the internet from state meddling in favor of a preference for top-down control by unelected political appointees, 3 of whom will decide what constitutes reasonable behavior. Through its actions, the majority is inviting countries around the globe to do the same thing. Reasonable is a subjective term. Not only is it perhaps the most litigated word in American history, its definition varies radically from country to country. The precedent has now been set for the internet to be subjected to state interpretation reasonable by governments of all stripes. In fact, at the United Nations just last Wednesday, a renewed effort by representatives from countries such as China and Saudi Arabia is calling for what one press account says is, quote, an international body made up of government representatives that would attempt to create global standards for policing the internet, end quote. By not just sanctioning, but encouraging more state intrusion into the internet's affairs, the majority is fueling a global internet regulatory pandemic. Internet freedom will not be enhanced, it will suffer. My dissent this morning is based on four primary concerns. First, nothing is broken in the internet access market that needs fixing. Second, the FCC does not have the legal authority to issue these rules. Third, the proposed rules are likely to cause irreparable harm. And fourth, existing law and internet governance structures provide ample consumer protection in the event of a systemic market failure. Before I go further, however, I apologize if my statement does not address some important issues raised by the order. But we received the current draft at 11:42 p.m. last night, and my team is still combing through it. First, nothing is broken in the internet access market that needs fixing. All levels of the internet supply chain are thriving due to robust competition and low market entry barriers. The internet has flourished because it was privatized in 1994. And at this point, I need to dispel a pervasive myth that broadband was once regulated like a phone company. Not only was the FCC's 2002 cable modem order unanimous, it did not move broadband from Title II. It formalized an effort started under Bill Kennard's FCC. But I will include a more thorough history as part of my statement. Since its privatization, the internet has migrated further away from government control until today. Its success was the result of bottom-up collaboration and not top-down regulation. No one needs permission to start a website or navigate the web freely. To suggest otherwise is nothing short of fear-mongering. Myriad suppliers of internet-related devices, applications, online services, and connectivity are driving productivity and job growth in our country. About 80% of Americans own a personal computer. Most are connected to the internet. In the meantime, the internet is going mobile. By this time next year, consumers will see more smartphones in the U.S. market than feature phones. In addition to countless applications used on PCs, growth in the number of mobile applications available to consumers has gone from nearly 0 in 2007 to 500,000 just 3 years later. Mobile app downloads are growing at an annual rate of 92%, with an estimated 50 billion applications expected to be downloaded in 2012, probably most of which will be downloaded by my children onto my iPhone. Fixed and mobile broadband internet access is the fastest penetrating disruptive technology in history. In 2003, only 15% of Americans had access to broadband. Just 7 years later, 95% do. 8 announced national broadband providers are building out facilities in addition to the construction work of scores more local and regional providers. More competition is on the way as providers light up recently auctioned spectrum. Furthermore, the Commission's work to make unlicensed use of the television white spaces available to consumers will create even more competition and choice. In short, competition, investments, innovation, productivity, and job growth are healthy and dynamic in the internet sector thanks to bipartisan deregulatory policies that have spanned 4 decades. The internet has blossomed under current law. Policies that promote abundance and competition rather than the rationing and unintended consequences that come with regulation are the best antidotes to the potential anti-competitive behavior feared by the rules proponents. But don't take my word for it. Every time the government has examined the broadband market, its experts have concluded that no evidence of concentrations or abuses of market power exists. The Federal Trade Commission, the FTC, one of the premier antitrust authorities in government, not only concluded that the broadband market was competitive, but it also warned that regulators should be wary of network management rules because of the unknown, quote, net effects on consumers, end quote. The FTC rendered that unanimous and bipartisan conclusion in 2007. As I discussed earlier, the broadband market has become only more competitive since then. More recently, The Department of Justice's Antitrust Division reached a similar conclusion when it filed comments with us earlier this year. While it sounded optimistic regarding the prospects for broadband competition, it also warned against the temptation to regulate, quote, to avoid stifling the infrastructure investments needed to expand broadband access, end quote. Disturbingly, the Commission is taking its radical step today without conducting even a rudimentary market analysis. Perhaps that is because a market study would not support the order's predetermined conclusion. My second point is the FCC does not have the legal authority to issue these rules. Time does not allow for me to refute all of the legal arguments raised in the order, the newest version of which we are still reviewing, but I will do my best. I have included a more thorough analysis in the supplemental section of this statement. Nonetheless, I'll touch on a few of the legal arguments endorsed by the majority. Overall, the order is designed to circumvent the D.C. Circuit's Comcast decision, but this new effort will fail in court as well. The order makes a first-time claim that somehow, through the deregulatory bent of Section 706, way back in 1996, Congress gave the Commission direct authority to regulate the Internet. The order admits that its rationale requires the Commission to reverse its long-standing interpretation that this section conveys no additional authority beyond what is already provided elsewhere in the Act. This new conclusion, however, is suddenly convenient for the majority while it grasps for a foundation for its predetermined outcome. Instead of, quote, removing barriers to infrastructure investment, end quote, as Section 706 encourages, the order fashions a legal fiction to construct additional barriers. This move is arbitrary and capricious and is not supported by the evidence in the record or a change of law. The Commission's gamesmanship with Section 706 throughout this year is reminiscent of what was attempted with the contortions of the so-called 70-70 rule 3 years ago. I objected to such factual and legal manipulations then, and I object to them now. Furthermore, the order desperately scours the Act to find a tether to moor its alleged Title I ancillary authority. As expected, the order's legal analysis ignores the fundamental teachings of the Comcast case. That Titles 2, 3, and 6 of the Communications Act give the FCC the power to regulate specific, recognized classes of electronic communication services, which consist of common carriage telephony, broadcasting, and other licensed wireless services and multi-channel video programming services. Despite the desires of some, Congress has not established a new title of the Act to police Internet network management, not even implicitly. The absence of statutory authority is perhaps why members of Congress introduced legislation to give the FCC such powers. In other words, if the Act already gave the Commission the legal tether it seeks, why was legislation needed in the first place? I'm afraid that this leaky ship of an order is attempting to sail through a regulatory fog without the necessary ballast of factual or legal substance. The courts will easily sink it. In another act of legal sleight of hand, the order claims that it does not attempt to classify broadband services as Title II common carrier services. Yet functionally, that is precisely what the majority is attempting to do to Title I information services, Title III licensed wireless services, and Title VI video services by subjecting them to non-discrimination obligations in the absence of a congressional mandate. What we have before us today is a Title II order dressed in a threadbare Title I disguise. Thankfully, the courts have seen this bait and switch maneuver by the FCC before, and they have struck it down each time. The order's expansive grasp for jurisdictional power here is likely to alarm any reviewing court because the effort appears to have no limiting principle. If we were to accept the order's argument, it would virtually free the Commission from its congressional tether to quote many past courts. As the Supreme Court explained in Midwest Video 2, quote, without reference to the provisions of the Act expressly granting regulatory authority, the Commission's ancillary jurisdiction would be unbounded, end quote. I am relieved, however, that in the order, the Commission is explicitly refraining from regulating coffee shops. In short, if this order stands, there is no end in sight to the Commission's powers. I also have concerns regarding the constitutional implications of the order, especially its trampling on the First and Fifth Amendments. But again, in the observance of time, those thoughts are contained in my extended written remarks. My third concern is that the Commission's rules will cause irreparable harm to broadband investment and consumers. DOJ's cogent observation from last January regarding the competitive nature of the broadband market raises the important issue of the likely irreparable harm to be brought about by these new rules. In addition to government agencies, investors, investment analysts, and broadband companies themselves have told us that network management rules would create uncertainty to the point where crucial investment capital will become harder to find. This point was made over and over again at the FCC's Capital Formation Workshop on October 1st, 2009. A diverse gathering of investors and analysts told us that even rules emanating from Title I would create uncertainty. Other evidence suggests that internet management rules could not only make it difficult for companies to, quote, predict their revenues and cash flow, end quote, but a new regime could, quote, have the perverse effect of raising prices to all users, end quote. Additionally, today's order implies that the FCC has price regulation authority over broadband. In fact, the D.C. Circuit noted in its Comcast decision last spring that the Commission's attorneys openly asserted at January's oral argument that, quote, the Commission could someday subject broadband service to pervasive rate regulation to ensure that a broadband company provides the service at reasonable charges, end quote. Nothing indicates that the Commission has changed its mind since. In fact, the order appears to support both direct and indirect price regulation of broadband services. Moreover, as lobbying groups accept this order's invitation to file complaints asking the government to distort the market further, the Commission will be under increasing pressure from political interest groups to expand its power and influence over the broadband market. In fact, some of my colleagues today are complaining that the order doesn't go far enough. Each complaint filed will create more uncertainty as the enforcement process becomes a de facto rulemaking circus, just as the Commission attempted in the ill-fated Comcast BitTorrent case. How does this framework create regulatory certainty? Even the European Commission recognized the harm rules would cause to the capital markets when it decided last month not to impose measures similar to these. Part of the argument in favor of new rules alleges that giant corporations will serve as hostile gatekeepers to the Internet. First, in the almost 9 years since those fears were first sown, net regulation lobbyists can point to fewer than a handful of cases of alleged misconduct out of an infinite number of Internet communications. All of those cases were resolved in favor of consumers under current law. More importantly, however, many broadband providers are not large companies. Many are small businesses. For example, Lariat, a fixed wireless internet service provider serving rural communities in Wyoming. Lariat has told the Commission that the imposition of network management rules will impede its ability to obtain investment capital and will limit the company's, quote, ability to deploy new service to currently unserved and underserved areas, end quote. Furthermore, Lariat echoes the views of many others by asserting that, quote, the imposition of regulations that would drive up costs or hamper innovation would further deter future outside investment in our company and others like it, end quote. Additionally, quote, to mandate overly burdensome network management policies would foster lower quality of service raise operating costs, which in turn would raise prices for all subscribers, and or create a large backlog of adjudicative proceedings at the FCC in which it would be prohibitively expensive for small and competitive ISPs to participate, end quote. Lariat also notes that the imposition of net neutrality rules would cause immediate harm such that, quote, due to the immediate deleterious impacts upon investment, these damaging effects would be likely to occur even if the Commission's order was later invalidated, nullified, or effectively modified by a court challenge or congressional action, end quote. And many other small businesses have echoed these concerns, and all of this is in the record. Less investment, less innovation, increased business costs, increased prices for consumers, disadvantages to smaller ISPs, jobs lost, and all of this in the name of promoting the exact opposite. The evidence in the record simply does not support the majority's outcome-driven conclusions. In short, the Commission's action today runs directly counter to the laudable broadband deployment and adoption goals of the National Broadband Plan. No government has ever succeeded in mandating investment and innovation, and nothing has been holding back internet investment and innovation until now. The fourth point of my dissent is existing law provides ample consumer protection. To reiterate, the order fails to put forth a factual or legal basis for regulatory intervention. Repeated government economic analyses have reached the same conclusion. No concentrations or abuses of market power exist in the broadband space. If market failure were to occur, however, America's antitrust and consumer protection laws stand at the ready. Both the Department of Justice and the Federal Trade Commission are well equipped to cure any market ills. In fact, the antitrust law section of the American Bar Association agrees. Nowhere does the order attempt to explain why these laws are insufficient in its quest for more regulation. Moreover, for several years, I've been advocating a potentially effective approach that won't get overturned on appeal. In lieu of new rules, which will be tied up in court for years now, the FCC could create a new role for itself by partnering with already established non-governmental internet governance groups, engineers, consumer groups, academics, economists, antitrust experts, consumer protection agencies, industry associations, and many others, to spotlight allegations of anti-competitive conduct in the broadband market and work together to resolve them. Since it was privatized, internet governance has always been based on a foundation of bottom-up collaboration and cooperation, rather than top-down regulation. This truly light approach has created a near-perfect track record of solving internet management conflicts without intervention. Unfortunately, the majority has not even considered this idea at the moment. But once today's order is overturned on appeal, it is still my hope that the FCC will consider and adopt this constructive proposal. In sum, what's past is indeed prologue. We left the saga of the FCC's last net neutrality order before was with a spectacular failure in the appellate courts. Today, the FCC seems determined to make the same mistake instead of learning from it. The only illness apparent from this order is regulatory hubris. Fortunately, cures for this malady are obtainable in court. For all the foregoing reasons, I respectfully, just in case you were guessing, dissent. Thank you, Mr. Chairman.
Thank you.